There is a legal structure that costs as little as $10 to create in certain states that can make your personal bank account, your home, your car, and every asset you own completely untouchable. Not hidden, not offshore, not illegal, untouchable. If someone sues you, they cannot reach your savings. If a creditor comes after a business debt, they cannot seize your house. If a frivolous lawsuit targets your company, the judgment stops at a wall that the law itself built, and it protects everything on the other side. The legal term for this wall is the corporate veil, and for roughly the cost of a fast food meal, you can build one around everything you own. The legal industry in the United States generates over $437 billion annually. A significant portion of that revenue comes from litigation, from people suing other people and seizing assets that were never protected. Asset protection attorneys charge between $300 and $700 per hour to build structures that start with the exact same $10 filing you could have made yourself. They did not make this complicated because it is complicated. They made it complicated because simplicity cannot be billed at $700 an hour. Welcome to the Invisible Ledger. If these stories matter to you, hit subscribe and the bell. This is where we trace the money they told you not to follow. The concept of a separate legal entity shielding individual owners from liability is one of the oldest principles in commercial law. It traces back to Roman law, where the societas, a form of business partnership, distinguished between the obligations of the business and the personal obligations of its members. By the Middle Ages, European trading companies, particularly in Venice, Genoa, and the Netherlands, had developed the commenda, a structure where passive investors could fund a voyage without risking more than their investment. If the ship sank, the investor lost their stake, but kept their house. The modern limited liability company evolved from this principle. In 1811, New York became the first state to pass a general incorporation statute, allowing businesses to form corporations with limited liability without a special act of the legislature. But the LLC, as we know it today, was born in 1977, when Wyoming passed the first Limited Liability Company Act, largely at the request of an oil company that wanted the liability protection of a corporation combined with the tax flexibility of a partnership. Florida followed in 1982. By 1996, all 50 states had adopted LLC statutes. Today, according to the IRS, there are over 36 million business entities in the United States, and the majority of new filings are LLCs. The corporate veil works like this. When you form an LLC, you create a separate legal person. This entity can own property, open bank accounts, enter contracts, and conduct business. It has its own tax identification number called an employer identification number, which you can obtain for free from the IRS in approximately 5 minutes on their website. The LLC is not you are the member, the owner. But legally, the LLC is its own entity. If the LLC incurs a debt, the creditor can pursue the LLC's assets, but generally cannot pursue your personal assets. If someone slips and falls at a property owned by the LLC and sues, the judgment attaches to the LLC, not to your personal home or savings account. This separation between the entity and the individual is the corporate veil. The filing cost varies by state. In states like Kentucky, the filing fee for an LLC is as low as $40. In California, you pay $70 to file but face an annual $800 franchise tax minimum. In New Mexico, the filing fee is $50 with no annual report requirement and no public disclosure of member names. Wyoming charges $100, but offers some of the strongest asset protection statutes in the country. Several states allow formation for fees in the range of $10 to $50 when combined with online filing tools and registered agent services. The point is not the exact dollar amount. The point is that the foundational structure of financial protection costs less than a single hour of an attorney's time. Now here is where most people make the critical mistake. They form an LLC and then treat it as an extension of themselves. They deposit business income into their personal checking account. They pay personal bills from the business account. They sign contracts in their own name instead of as a representative of the LLC. And when a lawsuit arrives and a judge examines their behavior, the court pierces the corporate veil. Piercing is the legal term for a judge deciding that the LLC was never truly separate from the individual, that it was a sham, an alter ego, and therefore the individual is personally liable despite the LLC's existence. The legal tests for piercing vary by state, but the most common factors courts examine include commingling of funds, failure to maintain separate records, failure to hold annual meetings or maintain operating agreements, undercapitalization of the entity, and use of the entity to perpetrate fraud or injustice. In the landmark case of Walkowski v. Carlton in 1966, the New York Court of Appeals addressed whether a taxi company owner could be held personally liable when each of his cabs was held in a separate, minimally capitalized corporation. The court held that mere undercapitalization alone was not sufficient to pierce the veil. The plaintiff had to show that the owner was conducting business in his individual capacity. Before I go further, this video is just the surface. Inside the invisible ledger vault, you will find the complete LLC formation guide for all 50 states, operating agreement templates, the essential checklist to prevent veil piercing, asset protection trust comparisons, and the exposed strategies that high net worth individuals use to layer multiple entities for maximum invisibility. The link is in the description. But stay right here. The asset protection industry knows exactly how powerful this simple structure is. That is why they have layered complexity on top of it to justify their fees. They will tell you that you need a Wyoming LLC, holding a New Mexico LLC, holding a Nevada trust, holding a Delaware Series LLC. And for individuals with multi-million-dollar portfolios, complex structures may indeed be appropriate. But for the vast majority of Americans, a single properly maintained LLC in their home state provides a level of protection that they currently do not have at all. Consider this. According to the American Bar Association, approximately 40 million lawsuits are filed in the United States every year. The probability that a business owner or property owner will face at least one lawsuit in their lifetime approaches nearly 100%. Without an LLC or similar entity, every one of those lawsuits can reach your personal bank account, your home equity, your retirement savings in some cases, and your future earnings. With a properly maintained LLC, the lawsuit reaches the entity and stops. Your personal assets remain behind the wall. The IRS itself provides the EIN, the tax identification number, at no cost through its online application at iris.gov. The entire process takes less than 10 minutes. Once you have an EIN and a filed LLC, you can open a dedicated business bank account at virtually any bank. This account is the LLC's account, not yours. All business income flows in. All business expenses flow out. Your personal account is separate. Your personal name does not appear on business transactions. You are, in the language of asset protection, financially invisible. If you have made it this far, you already know more about liability separation than 99% of small business owners in America. Subscribe and share this video. Now let me give you the exact steps. Step 1. Choose your state of formation. If you live and operate in one state, form your LLC there. The home state advantage avoids the complexity and cost of registering a foreign LLC. If privacy is your primary concern, consider New Mexico, which does not require public disclosure of LLC members, or Wyoming, which offers strong charging order protections. Step 2. File your articles of organization with the state. This is a 1 or 2 page document listing the LLC's name, registered agent, and basic information. Most states allow online filing. Step 3. Obtain an EIN from the IRS at irs.gov. It is free and takes minutes. Step 4. Draft an operating agreement. Even if you are the sole member, an operating agreement establishes that the LLC is a real entity with real governance. It outlines how profits are distributed, how decisions are made, and what happens if the entity is dissolved. This document is your primary defense against veil piercing. Step 5. Open a dedicated business bank account using the LLC's name and EIN. Never deposit business income into your personal account. Never pay personal expenses from the business account. Step 6. Maintain records. Keep minutes of major decisions. File annual reports if your state requires them. Renew your registered agent. Treat the LLC as what it is, a separate legal person. Total cost? As low as $10 to $50 in filing fees plus a few hours of your time. Compare that to the $300 to $700 per hour an asset protection attorney charges, or the potentially unlimited personal liability you face without any entity at all. I need to be honest with you. An LLC is not a force field, and there are real limitations. First, an LLC does not protect you from your own personal wrongdoing. If you personally commit fraud, assault, malpractice, or negligence, the LLC will not shield you from personal liability for your own acts. Second, many lenders require personal guarantees when lending to small LLCs. If you personally guarantee a business loan, the LLC's liability protection does not apply to that debt. Third, single-member LLCs receive weaker protection in some states. In states like Florida, a single-member LLC may be subject to charging order limitations that are less protective than multi-member LLCs. Fourth, veil piercing is real. If you do not maintain the separation between yourself and the entity, courts will disregard the LLC entirely. The protection only works if you treat it as real. And fifth, an LLC does not replace insurance. General liability insurance, professional liability insurance, and umbrella policies work alongside entity structuring. The LLC is a wall. Insurance is the moat. Your great-grandparents did not have LLCs, but they understood the principle. They kept the farm in a trust. They held property through family arrangements that separated what they worked with from what they lived in. For generations, families instinctively built walls between their livelihood and their life savings. Then, one generation was taught that simplicity meant putting everything in one name, one account, one social security number. A lawyer could find it all in an afternoon. There was not a simpler way. There was just a more exposed way. Subscribe and share this video. Every share teaches one more person how to build the wall the legal industry charges thousands to explain. The next vault opens soon, and what is inside involves a credit card bill, a 3-letter code called the UCC, and a single question that banks pray you never ask. Si ça escasse.